Hi everyone, my name is Briar. I am a lawyer from Hopgood Gannon Lawyers. We are Perth and Brisbane based, so it's good to be down here. I'd like to start by acknowledging the traditional owners of the land on which we meet today. I extend my respects to their elders, past, present and emerging. Like I just said, I'm a lawyer. I specialise mostly in the IP tech side of things, but part of what I do is help mostly indie game developers with their legals. So I'm going to be talking about negotiating with publishers, and thank you all for coming in what is effectively the lunch break. I really appreciate it. So first, I wouldn't be a lawyer without making a disclaimer. This isn't legal advice, it's general advice. Law is hard. I have spent a lot of time doing law, so it's less hard for me. Alas, law is still hard. And finally, this isn't legal advice. Tick that box. All right, a few things that I'm going to run through. I will try and get the balance right of going through everything properly and effectively and not labouring on any points as well, given we do have limited time. But license scoping, what are you giving up? What are you getting in return? Warranties, indemnities, termination rights, and things that annoy me. So, things you need to think about when you're negotiating with publishers. It's a balance of control and risk. What rights are you giving up? What are you getting in return? What guarantees are you making about what you're giving up? We'll start with license scoping. So what's a license? It's literally a right to do something, and in the context of game development publishing agreements, it's what are you doing with an IP asset? It's not an assignment. The difference between a license of your game and an assignment of your game is that when you're assigning, you're transferring ownership, whereas with a license, you're just giving someone a right to use it and do certain things with it. It can be described really, really broadly. So if you've seen publisher agreements before, has everyone gone through that process? Put your hands up if you haven't. Haven't yet? Okay, let me explain. So when you are negotiating with the publisher, you can give them really, really broad rights to do effectively everything, market, but also further develop, translate, that sort of thing. Or in certain circumstances, that isn't really appropriate, and you can literally just give them a right to market. So it can be a point-in-time license or ongoing, so you could be licensing your asset as it is at the time of making that contract, or you could be giving updates, that sort of thing. It's really important to get the subject matter right. What are you licensing? So for a game, depending on what stage of development you're in, it's the binary of the game, the associated art, trademarks and materials. It's not generally source code. When you are giving up source code, you are giving up a lot. You're handing over a lot of control. And so in some circumstances it is actually required and appropriate, but where someone's marketing a game for you, generally not. You don't want to give them the keys. Exclusivity. Does anyone know what the difference is between an exclusive license, a non-exclusive license, a sole license? A couple of blank stares, sort of, bit iffy, yeah?
What's the exclusive and sole difference?
Yeah. Okay, so a sole license is where you're allowed to do it as the owner, and the person you're licensing is allowed to use it, but no one else. So when you're granting an exclusive license, you're actually granting it against yourself as well. Yeah. And that gets people tripped up a little. So exclusive, no one else can do anything other than your licensee in respect of what you're licensing. Non-exclusive, it's a free-for-all. I'll license it out to other people as I see fit. A sole license, I can still use the rights in my work, and you can, but no one else. There are certain restrictions in a license that are probably appropriate, depends on the circumstances, and you'll hear me say it depends a lot. I am, after all, a lawyer. The term, how long do you want this license to go on for? Is it a fixed term arrangement? That sort of thing. Territory, do you want to be restricting to certain countries, states within a country, that sort of thing. Purpose, do you want to limit that license to only be used for a particular purpose? That can be very important sometimes. You don't want to give your game over to a publisher for them to use for whatever purpose. Usually there's more targeted right there that you want to limit it to. Can the publisher then, on forward that license? Can they then license to other people to exercise the same rights in the license that you gave them? Most of the time, that's not appropriate. It sort of depends sometimes as well if the publisher is massive and they have other affiliates that also want to publish the game. Sometimes that might be appropriate, but it can also be a red flag. Limited publishing activities. Are you dictating what they can and can't do in conducting those publishing activities? And then any prohibited use. The usual stuff is reverse engineering, that sort of thing, but have a think about all the things you think they should not be doing with your asset. So I've got an example here, and if you went to my talk last year, this may look a little bit similar. It didn't work out. A lot of my examples are from the same agreement, and they're all the red flag examples. And unfortunately, with this developer, they just chose not to go ahead. I would say generally that's very rare. Publishers aren't out to get you, generally. But they do have to put their strongest position forward to you in a contract. And a lot of the time they expect you to negotiate. So don't feel like you can't negotiate with publishers. These examples are just times that it went really wrong, but they're good by way of example. So this was an agreement for a binary, the binary in a game, and I'll let you have a little bit of time to read through, and I will quiz you, but I'll come back around to save you just if you need. And for anyone who can't read it, the developer grants to the publisher an exclusive, sub-licensable, transferable, worldwide license to use and modify the apps, which in this case were the games on different app stores, reproduce, distribute, transmit, translate, publicly perform, publicly display, modify, publish, store, and create derivative works of the developer's content, and all the rights associated with the development's intellectual properties for the sole purpose of publishing and marketing the game on the target platforms. And then the definition of developer's content was all the content, such as source code, artworks, text, sounds, character designs, and logos created by the developer. Can anyone point out any red flags? Yes?
They just took full ownership. If it's sub-licensable and transferable, they can throw it around.
They can send it anyway, and you don't really have any way of tracking what's going on with your game. Anyone else? Yes, the person closest to me. Yeah, it was meant to be a binary license, and so we're licensing source code. Yes? Yeah.
You're granting them a right to create derivative works in the developer's content, so that includes prequels, sequels, other type of mediums?
That was definitely a problem in this one. Yep, over there.
You've also given them the rights to use and modify the game.
Yeah, and they didn't have to in this, yeah. And that can be okay if that's what you expect from your publisher, but in this instance, the developer wasn't expecting that. So it was an exclusive license and it was worldwide. So you're not able yourself to use it anywhere. It was sub-licensable, which can be, if you're negotiating a royalty arrangement, sometimes that can get you into hot water because the person who's actually publishing the game is no longer the licensee that you're dealing with, and so they don't owe you royalties, but who does? You have to be really careful. To use and modify it, the developer hadn't thought that anyone was going to be modifying the game. It was literally just marketing. As we pointed out, create derivative works of. And then the developer's content was just really broadly described, which in this case wasn't appropriate. Source code, artworks, text, sounds, character design, and logos. The latter part's probably okay. It also didn't, for some reason, limit that definition of developer's content to the game. It was just all intellectual property of the developer. And so he had other projects going on and he was like, I don't really understand why they want everything. And they didn't. It's just bad drafting. So, well, it's typical. It's my first it depends. What did you actually discuss with the publisher? If it doesn't align with what you discussed, then you probably need to go back to the drawing board. What market are you tapping into via the publisher? If they're really well known in Europe, do you want to be limiting your license so that they only market in Europe and you can keep conducting your activities elsewhere? Do they need the freedom to adapt or change the game? What is it that you're hoping to get out of them? If they're just marketing, probably not. How your royalty is structured, and that sort of goes back to that sub-licensing issue. You don't want your rights to be diluted when you're trying to get money from people. And just separately on the subject of IP, I know Cam Rogers Legal will be doing something on IP later, but it sort of all connects. When we're talking about licensing an asset, what happens then once you're still improving it and further developing it? You need to figure out whether that needs to be licensed as well. This is an example of such a clause. On creation, all intellectual property rights in and to the game and associated materials shall be owned by, an assignment. Who's owning what? When you got improvements, who's making the improvements? Sometimes it's the publisher, if you've given them creative license in the market. Sometimes it's you, though, if you're improving in the background. You need to make sure that the ownership details are right. Warranties. Big scary. What is a warranty? It's a guarantee or a promise from one of the parties. A breach of a warranty entitles the aggrieved party to sue for damages. In publishing agreements, we typically see warranties about IP ownership and non-infringement. So I own the things that I say I own, and that those things don't actually infringe the rights of someone else. Illegality, this game, if I publish it over here in this market, isn't going to breach any laws. And a warranty against defects, we know what a product warranty is. We'll fix things if bugs occurs, that sort of thing. An example from the same agreement. But this is fairly typical. The developer is the registered and beneficial owner of the game. It has good title there too, and that the game and the developer's ownership therefore are free and clear of any lien, encumbrance, claim, litigation or arbitration. So there's no ongoing litigation in respect of the game. The game does not, and the developer's content does not violate any law or infringe any third-party rights. None of the apps have ever materially infringed the guidelines, terms, conditions or rules applicable to them. The game is not subject to the terms of any license that provides for any source of the game's software to be disclosed or licensed to the public. So it's not got any viral code in it from like open source. So there are certain warranties, absolutely, that you can give. There are some limitations that you should think about. How extensively have you done searches to make sure that your IP definitely doesn't infringe the rights of someone else? Can you even do that when patent registrations are very secretive and you would have to have not infringed someone's patent anywhere around the world? Territory. Have you done some really good due diligence in Australia but you don't really know what the status of laws applicable to game development are in Italy? Then maybe you need to think about limiting that. Is there a warranty period for any defects? Does it only last a year, 2 years, 5 years? Can you actually give the warranties that you're being asked? Because if publishers sort of appreciate you being upfront with them, and if there are things that you just can't guarantee, you might want to have the conversation and say, well, I might cover your costs if something happens and, and we end up being liable for something that I can't guarantee, though. I don't want you to be able to terminate, but I might cover your costs for it, which is an indemnity. An indemnity is a promise to compensate the other party for loss or damage that they suffer in certain circumstances. Again, it's something that can be very broad or very limited. In the legal world, we call it an insurance policy because your publisher is effectively taking out from you an insurance policy in case something happens. But we usually refer to indemnities as insurance policies when they're too broad. Get your own insurance. Don't come after me. It is different to holding someone harmless. When you hold someone harmless, you absolve them of legal liability. With an indemnity, you don't actually have to discuss liability necessarily. You can just say, if something happens and you have costs, I'll pay for it. Having said that, you need limitations. And in publishing agreements, there's usually an indemnity to the publisher for IP infringement claims. So someone comes after you for usually copyright infringement, and you pay the publisher's costs if they come after the publisher, because the publisher is the bigger person to come after and probably has loaded pockets. Non-compliance with applicable laws. Sometimes any or breach of the agreement. So sometimes you'll see parties indemnifying each other for breach of the agreement. And indemnities usually survive termination, so they usually exist in perpetuity. From that same agreement. I'll read it out. The developer will at all times defend, indemnify, and hold harmless the publisher from and against any and all losses incurred or suffered by the publisher in relation to any and all claims or allegations, actual or threatened, that the publisher's exploitation of the game with the aim of publishing and marketing the game under the agreement, this is all one sentence, infringes any rights of third parties to the apps, the developer's content, or the developer's intellectual properties. Furthermore, the developer will at all times defend, indemnify, and hold harmless the publisher from and against any and all losses incurred or suffered by the publisher in relation to any and all end-user claims or allegations. I tried to do it in one breath. Actual or threatened for damages directly or indirectly caused by the apps, the developer's content, or the developer's intellectual properties. I won't be mean. Here are the issues. It's really, really broad. Any and all claims or allegations, actual or threatened. So, and if it's nonsense, then you're still indemnifying the publisher for their costs. As the bigger company, maybe the publisher should be taking on some risk in taking on your game and making it famous. The other thing generally is as well is it's not capped, so you're liable for an undisclosed amount. And it's also not limited to any contribution of the publisher to that liability. So if they've done the wrong thing with your game and you've said, hey, don't do that, like we don't want to target minors or that sort of thing, it's not limited in the language. Any and all end-user claims or allegations, actual or threatened, for damages. It's just really, really broad. And yes?
Doesn't defend there effectively mean that if the publisher is prosecuted, that the developer needs to?
Yeah, you sort of step in. Yeah, you step in. Yeah. So that it's something that I'd explain in more language, I think, if I were to use it. But yes, defend, indemnify, and hold harmless. So you're the one stepping in to act for them. You are indemnifying them, so you're paying their costs, and you're also holding them harmless, so they have no liability. It's just really broad, yes.
So if they also have one of the claims that where they can make changes to it, does that suddenly mean that you have to pay for it if they make a change?
Yeah, if they've done something dumb, because you've given the license for them to do that, without any clarifying wording, it's anything, which is why this agreement didn't go forward, really. This is a bit more balanced, this one. Each party will indemnify and hold harmless the other party from and against all loss, damage, and expense awarded by a court of competent jurisdiction or settled with the violating party's prior written consent, resulting from any third... Oh, we've lost it. No.
Hold your harmless.
Don't use my words against me. What's going on? Oh. Okay. I swear I didn't touch anything.
Any GCAP staff, if you
Should I press the button? Should I press the tech button? Oh! She just walked on over and she fixed everything. Thank you. Where would we get to? Resulting from any third-party claim arising out of the breach by the violating party of any of its obligations, and claims attributable to the infringement of any third-party intellectual property rights by the violating party. So we've limited the indemnity to two things: breach of the agreement and third-party IP claims. Yes?
As someone who's got quite an extensive background in insurance, do these examples
Yeah, so a liability cap, not in publisher agreements so much, but generally in contracts generally and IP agreements, yes, you'll see that one way to limit your indemnity obligations is to subject it to a cap, and sometimes that can even be the amount recoverable under insurance. It doesn't get through very often.
So is it similar to the way that like a public liability coverage will have a limit of 20 million? Just
Yeah. Yes. And when you're negotiating liability caps, you can also have a different cap for different types of breaches of the agreement. So if we're talking any old breach that isn't material, one cap applies. If we're talking about breaches of privacy, intellectual property claims, you could maybe set a separate higher cap for that. That generally makes the publishers feel a little more comfort. So it's only in respect of those two things. It's mutual, which is good. This one wasn't subject to a liability cap, so that was something to think about. And then there was some extra wording at the end. We only indemnify to the extent the aggrieved party has not contributed to such a breach or infringement by acting unlawfully or in contravention of the agreement. So if it's both ways, but if the publisher went and did something that you hadn't endorsed, that was in breach of the agreement anyway, and then they tried to say, well, you owe us for under the indemnity, you could say, well, you contributed to that, buddy. So it's a little more balanced. What is typical? It depends. Some things to think about with indemnities, and they're scary and they're sticking points, and everyone hates negotiating over indemnities, but they're really important. What are the key things that each party could do to ruin each other's year that you have no control over? That's generally what we start thinking about when we're talking about indemnities. Well, I could be publishing your game and you've told me that it's all gravy and it doesn't infringe anyone's IP, and then someone sticks their hand up 2 years later and says, hey, I'm going to sue you. The publisher has no control over that if they've acted in accordance with the agreement, and so they're going to want an indemnity for it. Sometimes you can use an indemnity as a substitute for a warranty if you can't give a promise that things are going to be all gravy and that there's no viral code in something because you've used something from open source, then maybe you can indemnify them for it with limitations. IP infringement indemnities are really, really common. They can be reasonable. But open-ended indemnities, insurance policies, are never reasonable. Consider whether there should be a time limit. Is that appropriate? Territory-based. Are there trigger events? For example, certain breaches or unlawful conduct that gives rise to an indemnity obligation. What constitutes loss or a claim? So a lot of people ignore this part. So when someone's incurring loss or there's a claim made against them, what does that mean? What is the scope of that? What counts as loss? Is it really everything, and really indirect loss can be counted? Is it claims that have been substantiated, or is it anything that someone asserts you've done something wrong? What if the publisher contributes to the breach? So we've talked about that. And also a monetary cap, really good idea. Termination rights. So termination is different to a term expiring. So if a term expires, it sees out the natural term of the agreement and it ends when everyone thought it was going to end. Termination is the early end to the agreement. When in a publishing agreement, you can have mutual or unilateral termination rights. It can be automatic or something that a party has to exercise to trigger. In publishing agreements, you'll see termination rights for breach and failure to remedy a breach. So where someone's breached the agreement, you've been given 30 days to fix it, or where breach is not capable of remedy in the first place, so IP infringement, can't uninfringe something. Insolvency, so where someone's gone bankrupt, out of business, can't pay their debts. Sometimes there will be a termination for convenience clause, so just because you feel like it, usually with notice. But if I was acting for a developer and a publisher asked for that, I'd try and strike it out. And reputational damage happens a bit too, where you're, putting yourselves out to be really inclusive and some workplace incident comes up, the publisher's probably not going to want to keep dealing with you, and so they're going to want an out. This is not controversial, but just an example. This agreement shall be effective from the date of signature and shall continue for the term unless terminated by either party, giving the other written notice in the event that the other is in material breach of the agreement, including failure to make outstanding payments due under this agreement, and in the case of material breach capable of remedy, fails to remedy the breach within 30 days of being required by written notice to do so, or the other party suffers an insolvency event. And usually you can see that's capitalised. Usually there's a lot of different circumstances that you'd want to describe as falling under that defined term. So not just that you're being wound up, administrators have been appointed, failure to pay debts and that sort of thing, as and when they fall due. Yes?
So I've recently heard of sort of situations where publishers, in the middle of the process, backed out and decided maybe they've run out of money, or, the economy's, for whatever reason. Could you provide some perspective as to what would you still owe that publisher, or what do you still owe each other at that point?
Usually there's like a consequences of termination clause, and when you're doing good drafting, you sort of want to do that. You want to say, step out what happens if someone terminates early. And so if it's on the publisher's paper, sometimes it doesn't exist and you have to sort of work out what you do then. But sometimes you'll have a consequences of termination clause and it'll step out who returns what, how much you're still getting paid, what happens. But when people go out of business, it becomes really, really hard to do anything, because you end up just being, if you're owed money, you end up just being put on the list of creditors and you have to fight it out with everyone else. So you want to sort of figure out sort of in the contract what you do when that occurs. It's sort of hard at the moment as well, particularly with IP licensing. You sort of can't try and put yourselves ahead of other creditors. It's not seen as there's the ipso facto regime, which is now in place, that we don't do that anymore. So you can't actually put yourselves ahead of other creditors. You have to sort of throw yourself in with the pile. But there are some creative ways to try and claw back the IP that's been shifted, and trying to get some money back. It's hard. Yeah. Was there a question? Yes.
I was just wondering, in the consequences of termination clauses, whether developers have been trying to get some language around the GCO in there.
I haven't seen it yet, but yes, absolutely that would be.
Sort of like if the publisher pulls the funding and the game can't get released, then you can't get your GTO.
Yeah, well.
Kind of like if as the developer you've been carrying the risk of cash flowing that tax.
It ends up being all about money, which can be hard again, because if the publishers come out of it because they've gone bankrupt, then you're still a creditor, and you can put something in there to try and reclaim it. But the problem is that you have to try and frame consequences of termination clauses as not being a penalty. So you're not getting back money because they've done something wrong or they've terminated. So it's I haven't seen it yet, but I think it'll be something that people think about, that if I've now got, I'm out because of this, then maybe there's a set amount that you get back proportionate to how long you've been in it and what you would have been owed. Yeah. It's not something I've seen yet, though. Okay, some things to consider about termination clauses. In what circumstances would each party want to terminate? A lot of the time you will get this blanket, each party may terminate because of breach, but then you probably need to think about, well, what other circumstances apply where I would want to get out, and those are probably very different to where the publisher would want to get out. What's the middle ground? So it's all about that balance and that push and pull of, I want all of these things, I want all of these things. Under what circumstances do I really want to be able to terminate this, and what comfort can I give the publisher so that they can get out? I mean, again, publishers need to assume a little bit of the risk because they're sort of taking a chance and they see some potential, and they're in the business of doing it. But it's also not really reasonable to say, well, you guys assume all of the risk and give me my money. So under what circumstances should people be able to terminate? Both parties should have some KPIs in your agreement, and if they fail to meet them, there should be consequences. Sometimes we see that it's very biased against the developer, where they have all these milestones to achieve and then, pretty serious repercussions. But what are you wanting to get out of your publisher? Have a think about that. And what do you want to do if they don't? Do you want to try and find someone else? Because that's usually the optimal position, right? Doesn't work out. I want to go somewhere else because I can see potential there. But if a developer doesn't have a termination right, it gets complicated. What should happen after termination? So that consequences of termination clause. Is the license to the publisher revoked? Yes, and often it is if you imply it, but please actually expressly state it. Get someone to go, yes, it's revoked. Is there a transition out period? What happens to the people who've downloaded the game with the publisher? All that sort of stuff. How do you transition all of those things? Is there a period where they're still able to market it and then it slowly gets filtered back to you? Is there a return or destruction of confidential information? You will probably give them a lot of confidential information that you probably don't want them to hold on to if you don't have an agreement anymore. What happens to the money that is paid or to be paid? Is there a period where you decide, if you terminate at this point, I get this amount. If you terminate at this point, I get this amount, but not if I'm the one who screws up. Things to think about. I get really worried when there's no consequences of termination sort of thought about and it's just a termination right. What happens after? Other things that annoy me. If you know me at all, there are a lot. Unlimited liability. Liability caps are awesome. Cap your liability, please. Disclaim liability. Exclude liability. What a fun time. You don't want your agreement to be completely open-ended and you just don't have a threshold that gets met. Because a lot can go wrong and, publishers know that and that they're in the business of it. So you don't want to be up for millions and, this project is the only thing that you'll ever do. You want to be able to keep innovating, move on to other things when things go wrong. Incomplete commercials and schedules. I know it's such an annoying thing to have to completely fill out a schedule about the money and the payment terms and all that stuff, but if you guys have a dispute or you want to terminate and you don't know what rights you have and it's all in the commercials and you haven't filled the commercials out, I then have to go, well, what did the parties say they were going to be doing at the time? What can we infer from the correspondence they had? What does the law say when you don't have terms? Please make sure that everything is completed in an agreement. It's actually kind of important. No term or termination clauses. If it's just perpetual and there's no right to terminate, we have to do a lot of work to figure out under what circumstances you would have been able to terminate. So put in a specific term, say it's perpetual if it is perpetual, and insert some termination clauses. Get your lawyer to insert some termination clauses. Over-the-top termination clauses I really hate. When a publisher can terminate for any reason whatsoever, and there's a massive list of reasons, or it's just any reason. Termination for convenience clauses are a bit of a bugbear for me. I want really long notice periods if a publisher is going to terminate for convenience, or and making sure you get your money if they've just decided they don't want to do it anymore. Rollover terms. Actually, I'll leave that till later because I have an example. Powers of attorney. If you are granting a publisher marketing rights, don't allow them to file trademarks in your name or do things on your behalf, particularly not in an open-ended manner in a contract. You want to be able to keep control of things to the best of your ability. You don't want to have to think about when the agreement terminates and you don't have those rights. The publisher now has your trademarks, those sorts of things. Securing sequels and spin-offs, that's fine as long as you talked about it. But I've seen a couple where, the publisher hadn't spoken to the developer about it and they said, we've got the rights for the sequels and the spin-offs and anything that has the same characters and all that sort of thing. if you've already talked about it, it's fine. But if you haven't, I don't want to see that in the contract. Open-ended audit rights. So a lot of the time publishers will say, we can audit your compliance with the agreement, and we'll do that by giving you direction to send us your records, or having some SharePoint or something like that. Fine, and I kind of get why they would need to do that sometimes, depending on how they're paying you and what sort of control they already have over the process. But if they're being able to audit you whenever, multiple times in a year, that's when I start going, that sounds a bit unreasonable and a bit costly. And who's paying for the audit as well? If they're sending in accountants to audit your records, who's paying for that? Because that gets expensive. And I usually limit it to once a year. This example, just the gift that keeps on giving. So when we're talking about rollover terms, I'll read this one out to you. Upon execution of this agreement and in full consideration of the license, the publisher agrees to pay 20 grand. The agreement will last until 4 years after execution of this agreement and be automatically renewed for a further 4 years, unless one of the parties notifies the other of its wish to terminate. The publisher will have the right to terminate the agreement for any reason. After the renewal, the developer will have the right to terminate. What's wrong with this? There's probably a few things wrong with this, but when we're talking about rollover terms, what's wrong with this? What was really wrong with this was that he was only entitled to one payment, but the term renewed. So it's an 8-year contract. You're only getting 20 grand out of it for 8 years. And I think that was actually the stick that broke the camel's back. After all of the indemnity issues and the warranties, for them to have snuck in an automatic renewal and no obligation to pay in that renewed term, that was a bit of a kick in the teeth. And I want to reiterate, publishers aren't typically like this. This was just a bad one. I thought I would go through engaging a lawyer. Who already has a lawyer, has dealt with lawyers before? Simple. Was it simple? Okay. We come from different worlds, so I thought I might go through it. This is what we do. We go through law school, we do our practical legal training, we get graduate experience, we get admitted as lawyers, and then we're a lawyer. I'd probably say at that point I still knew nothing. I did study for 5.5 years. I did my practical legal training over a year with full-time in the firm that I'm in now. And when I got to my grad job, I went, oh gosh, I have not been prepared. There are many different types of firms, and different firms may suit you differently. Boutique or sole practitioner firms, they're the smaller ones. They can either be really specialised or they can be general lawyers. Mid-tier national, those are the ones with offices throughout Australia. And they're usually really broad commercial firms, so they have teams of people who specialise, but they will service a wide range of clients. Top tier international, those are the ones who are more likely to charge more, but are sort of seen as the pinnacle. I'm from a mid-tier firm, so I disagree, but there's a specialist and a generalist. I would say that when you are game developers and you want to negotiate publishing agreements, you probably need a specialist, someone who's done this before. There are traps that you can get into when you engage a generalist, but I would say like a media lawyer, a digital media lawyer is probably going to have done this a few times. Billables. Billables are how we charge, and well, they're traditionally how we charge and how you engage us. You pay for us doing X amount of hours, and that's split into 10 units per hour. So we'll talk about the 6 minutes. Every 6 minutes is a unit, and those are our billables. And then there's a hierarchy as well. It depends on how your firm is structured, but in somewhere like a top tier or a mid-tier firm, you would have paralegals, law graduates, solicitors, associates, senior associates, and then probably either special counsel or a partner. And for us, that's really prescriptive. Like, you know where you're going to sit and what your career projection is like. It means that usually, if you're in those bigger teams, your solicitors, your associates, your law grads are going to do the grunt work because they're cheaper. And then the people who are higher up in the ranks will do the settling of that work. They'll supervise. So they do a bit more of the big picture thinking, strategic. But when you're utilised really well, you don't spend most of your time doing drafting as a senior lawyer because you know how expensive you can get. So pick your firm wisely. Always ask questions. Some tips for choosing a lawyer. Prioritise word of mouth recommendations. Ask your friends and colleagues because people know when they've had a bad lawyer and a lot of the time good lawyers have had clientele who've stuck around with them for years. Review pages often do lawyers a disservice. You don't really go onto a review page unless you hate your lawyer and you had a really bad experience. So we're going to get lots of negative reviews. Hopefully not too many, but out of proportionately, the people who say we did a really good job, they don't really leave reviews. They just pay us the money. Seek an initial coffee, a meeting, or a phone call with those you're vetting. Check the firm's website. Does it look like your lawyer has experience in the things you're trying to brief them on? What articles have they written? Can you get a meeting for free and sort of vet them? Because it goes both ways, right? And then I would also say, this is probably a bit blue sky for me, but ethics. Does your firm run your lawyer into the ground? If so, they're probably not going to be as available for you as you need. They're probably going to have lots of work on and they might not be that happy. And I think we all know now that burnout is a thing. We don't do as good a job when we're feeling like we're under lots and lots of stress. And unfortunately, with billables, you have targets to meet. And a lot of the time, that can run people into the ground. You want a firm who supports their lawyers to do really good work for people, working flexibly, all that sort of stuff. I know in your industry, we're sort of coming along with that. We're a little bit further behind, I think, and so we're slowly catching up. I think if you have a happy lawyer, your lawyer's going to work really hard for you. What else? How to keep costs down. Stay abreast of charge-out rates. A lot of lawyers will have a rate that they charge out at. If your lawyer is senior, do they list assistants from juniors who charge at a lower rate? So you get some sort of blended rate that sort of works in the middle. There are many, many different ways to cost a job. We don't need to rely on billables anymore. Probably shouldn't have ever, but that's the traditional model. Ranged estimates. I think this will cost from this to this. Fixed fee work. I will do that work for this fee. Capped fee work. I will do this work up to a monetary cap and I won't charge any more. Monthly retainers. You guys probably won't need to think about retainers, but we have a client who we charge a set amount every month and we just do anything that they send us. Blended rates. A bit of both, a bit of any of those things. What works for you? Seek free fixed price initial consultations. Make your instructions as clear as possible and gather your thoughts. If I have to read multiple documents to figure out what I'm doing, it's just going to cost more. It's going to take up more of my time. So if you can set out what you need from me ahead of time, it always really helps. And if I get subsequent emails while I'm trying to do the job, it ends up taking more time. Understand your client agreement. So when you get a client agreement from a lawyer, it's really tempting just to sign it and go, yeah, all good, and not think about it. Please read through particularly what your rights are in dealing with a firm, but also what the scope of the matter is and how the lawyer has described it. So you need to make sure it aligns with the work that you expected to be done by a lawyer. Yes?
Have you ever done an agreement where the publisher agrees to pay the developer's lawyer fees?
Yes, yep. So a publisher may agree to pay the costs of outside of the the agreement that you have with your lawyer, yes. So it might even be in the publisher agreement that the publisher agrees to cover the legal costs up to a certain amount. They don't really tend to like to do that, but so it depends. Yeah. I mean, it's really common in funding agreements. So, and that's the other thing. If you are thinking about getting funding, a lot of the time your legal costs will be, up to a certain extent, will be covered. You are entitled to regular updates on progress from your lawyers and fees. So it changes from state to state, but we are obligated to be really upfront with you about what we charge, where things are at. So use that. Don't just go, oh, well, I haven't heard from them for 2 weeks, but it should be all good. Check in, force us to do good work for you. Don't be afraid to ask. I know there's a little bit of elitism that goes on in the law space and in professional services, but don't feel like you don't have rights. I was the first person in my extended family to go to uni. I get it. Oh, woo! Very proud, but also I get it. You need to be able to advocate for yourselves. And, you know, as someone who's sat in this industry for a while and had horrible imposter syndrome and just felt like I didn't deserve to be there, you need to advocate for yourselves. And it's the same with publishers. You have to put your best foot forward. They will give you what they think protects their rights the best. It's up to you then to push back on things within reason. Are there any other questions? Yes.
Do you have any examples of good publisher KPIs that you've seen in relation to this?
I guess you want to look at reach and then also how many licenses are being bought and that sort of thing. So if you have a good idea of what that should look like in particular territories, that's what you need to focus on.
Sales figures?
Sales figures, it could also be like, I need you to show me what your marketing plan is. You need to have this developed by this point, and we need to make sure that we're sticking to it progressively. I need to see materials that you're putting out there, that sort of thing, and making sure that you're holding them to a standard. Yeah. Yes?
My question was kind of like, the KPIs, I was understanding them as developer only, but what KPIs on the publishers as well? So for instance, like user acquisition numbers and stuff like that?
Yeah, I mean,
Marketing.
you absolutely can put it in there. I mean, it's all a balance of what people will accept, but I think you should be trying to hold your publishers to a standard as well. It's not just all on you guys. Yes?
So these kind of agreements are usually confidential, right?
Hi, sorry.
Can you hear me?
Yeah, sorry, go on.
So these kind of agreements are usually confidential, right? Like publisher agreements.
Yep, there's usually a confidentiality clause, yes.
So they'll make you sign that before they show you the contract.
An NDA, separate NDA?
Yeah, that's what
Okay, yes. So usually they may get you to sign an NDA, otherwise there will be confidentiality clauses within the publisher agreement as well.
Yeah, so I'm just wondering how, like, you warn people about these bad agreements that you might have seen at a particular publisher without violating those agreements.
I generalise. So these examples have been rewritten by me. Yeah. So they've been de-identified. The content of them is not confidential to that extent because we're not identifying anyone. Yeah. And I've rewritten them. I've paraphrased. Yeah. Yes.
For a publisher, how valuable are those indemnity clauses if you're thinking
Really?
essentially less cash than publisher?
Yeah. Well, you
And
give.
say you've got a vexatious claim of IP infringement against the publisher, but they've got this brilliant clause that says all the liability that's on the developer in a real sense. The developer doesn't get cash for that. Who's actually legally liable?
Yeah, well, it's not about liability at that point. It's about I've incurred costs for this thing that I said I could be indemnified for. You're going to pay me for it. Liability, quite often when you're talking about indemnities, you sort of think about the trigger event and whether that has occurred. You can get into a scuffle about liability if there's some wording in the indemnity to suggest that liability has to occur first, but there are also clauses somewhere else in the agreement which says the party doesn't have to be liable to actually have to indemnify. The party doesn't have to actually have costs or losses to get that indemnity. So it's sort of a bit of a free-for-all sometimes, and that's why they need to be limited. Last question, yeah, Thea?
Is it recommended to look over clauses and paperwork that discussed, is it advisable to draft up those that paperwork and talk to a lawyer? Do you plan on self-publishing?
Yeah, I think, well, if you're self-publishing, then what terms are you, as for your own terms?
So say you and a number of other people are in a joint venture
Yep.
agreement, would the same kind of terms apply?
Yeah, sort of. I mean, these sorts of terms, I might see if I can get back to the agenda. They apply for a lot of different contracts. It's really just contract law at the very base of it. So you would probably be thinking, there we go, what is the scope of the license, particularly with a joint venture? What am I giving to the other joint venture participants? What am I getting in return? What promises am I giving about my contribution? And who am I? Indemnities are hard, always, and they're always a sticking point in negotiations, but what is it that I want to be covered for if something goes wrong? How do we terminate the joint venture arrangement? So with something like that, yes, these sorts of concepts sort of apply to all sorts of agreements. Yeah. Okay. I'll go right to the end because I don't think there's actually anything else, but I'll just check. No. There are my details if you need to contact me, if you want me to help you vet a lawyer, if you want to engage me, save me from doing telco agreements. Please do. Shoot me an email. Thank you.